Afternoon, as well as Ms. Charity Nzuza, the Executive Officer of the Legal Practice Council. We are pleased to continue our collaboration with the Property Practitioners Regulatory Authority, the PPRA, for what is our second joint webinar. There are several matters still under discussion between the LPC and the PPRA, and I am confident that our engagement will continue to grow. In recognition of this important relationship, the LPC National Council has approved this platform for the PPRA to address you directly and share information that they believe is pertinent to legal practitioners. Before we hand over to our guest, I want to extend the LPC's sincere gratitude and acknowledgement to the majority of you practitioners who demonstrate exemplary conduct in providing legal services and guidance to your clients. On that note, we would also like to remind all legal practitioners of the importance of paying your annual fees to the LPC. This not only ensures that you remain in good standing, but also helps sustain the LPC's ability to adequately regulate the profession and protect the public. It is also important to ensure that the LPC has your latest contact details, including your email, office address, and contact number. For those who are not aware, my name is Karen Jeevan, and I'm the Director of the Western Cape Office of the Legal Practice Council. It is now my pleasure to hand over to our speaker, Mr. Clarence Caton, the Executive Manager for Investigations and Enforcement at the PPRA. Thank you for your attendance.
Good afternoon. Sorry to disturb you, Charity Nzuza here. Kabelo, I see some people are still coming in. I don't know if you mind maybe just waiting for 3 minutes to see if you can get the bigger audience. I know that it's supposed to start at 2, but if this will benefit more people, maybe I'm sorry to the PPRA. Can we just give them maybe until 14:05?
Noted.
So that, yes, thank you so much.
All good. Thank you.
Sorry to jump into your webinar.
No, all good. All good.
Kabelo?
Yes, sir. Yes, sir.
Can you just confirm, because I can't see my screen, is my camera on your side?
Yes, your camera is on and your presentation is still on.
Okay.
So if we can wait maybe another 3 minutes, then we can proceed. I'll give you an indication to proceed, sir. Thank you.
All systems go, Kabelo.
Thank you, EO. Good afternoon again, legal practitioners. I will not redo the introduction. My Western Cape Provincial Director has already welcomed everyone. I just want to point out that today's session is being recorded. So after the session, the recording will be available on the LPC YouTube channel. I also encourage practitioners who have not yet followed us on our social media, Facebook and X, or Twitter as you know it, to also follow us on those platforms. If there are questions, please use the chat or the Q&A. And then at the end of Mr. Caton's presentation, between myself and Mr. Tembinkosi Ngobo, a member of the LPC team, we will then facilitate the question and answer session and direct them to the speakers. So welcome everybody. Without wasting any time, I'd like to now hand over to Mr. Clarence Caton from the PPRA. Mr. Caton, over to you, sir.
All right, thank you, Kabelo. Kabelo, I trust that my camera is on. I'm going to leave my camera on just for introductions purposes. So my name is Clarence Caton. I head the Investigations and Enforcement Department at the PPRA. And let me take the opportunity to thank LPC members to taking time off on a Friday afternoon, come and listen to us. I appreciate your attendance. We also appreciate the LPC for the opportunity to come and present on their platform and address their members. All right, so I'll start with my presentation. I'm going to switch off my camera, if you don't mind. Thank you. All right, so just move my... All right, so the purpose of this presentation is threefold, really. Firstly, we want to provide you as LPC members with a brief overview of who the PPRA is and what its mandate is, all right? The second purpose of the presentation, or let me say the second topic of the presentation, is that we want to remind conveyancers of the obligations in respect of the payment of commission to estate agents. And then the third topic is we want to follow up on the recent communique that was released on the 2nd of June, and that dealt with prohibited arrangements between estate agents and conveyancers. So that will be the three topics that I will discuss briefly in this presentation. So let us start with the first topic. Right, so as I said, the first topic would be to provide a brief introduction to who the PPRA is and what our mandate is. So PPRA, like the LPC, is a creature of statute and was established in terms of the Property Practitioners Act 22 of 2019. The Act came into effect on the 1st of February 2022, and on this date, the PPRA came into existence and took over the functions of the erstwhile Estate Agency Affairs Board. Right, so one of the new developments that was brought about by the Act is that it introduced this concept of a property practitioner, right? And that is the concept of a property practitioner is a broad definition which encapsulates the 11 different categories of professional specialities in the property industry. And examples of these specialities are estate agents, managing agents, auctioneers, bond originators, timeshare practitioners, and developers who market and sell their own properties. All right, but we just need to highlight a distinction here with developers. It's only developers who market and sell their own properties that are regarded as property practitioners. Developers who appoint estate agents to do the marketing and the selling of those properties are not included in the definition of a property practitioner. Another important introduction that has been made by the new Act is that it included a mandate for PPRA to transform the property sector. So what is meant by that is that PPRA has to put measures in place to ensure that new entrants are assisted to come into the market, and specifically new entrants from members who have come from previously disadvantaged backgrounds. So that is one of our main mandates. Besides regulating the industry, it's to transform the industry as well, and to facilitate the entrance of new entrants into the property sector. We want to ensure that estate agents, managing agents, auctioneers from previously disadvantaged backgrounds are assisted in coming into the sector and practicing and thriving. And so we've got programs which we have in place to assist with that. All right. So let's have a look at what our mandate is. So in terms of Section 6 of the Act, it tells us that we must do the following. We must regulate the conduct of property practitioners in dealing with consumers. We must regulate the conduct of property practitioners insofar as their services are concerned. We must regulate and ensure compliance with the provisions of the Act. We must protect consumers from undesirable and sanctionable practices. We must provide for the education, training, and development of property practitioners. And we must inform and educate consumers about their rights. And as I indicated, we must implement measures to ensure that the property sector is transformed. So these are our functions, the reason for our establishment and for our existence as the PPRA. Right, so let's have a look at our legislative framework. So the powers that are granted to us to perform the functions that I've just described are derived from the following pieces of legislation. Firstly, the Property Practitioners Act, which came into effect on the 1st of February 2022, which brought the PPRA into existence. And then the Property Practitioners Regulations, which have been promulgated in terms of the Property Practitioners Act. And then part of the Property Practitioners Regulations is the Code of Conduct for Property Practitioners. All right, so that's just a very brief, high-level overview of the PPRA and its functions and where it derives its powers from. If I should summarize our functions and the reasons for our existence, I would say that we've been established to regulate, to educate, and to transform the sector. Right, so now that you have a brief overview, let's move on to topic number 2. And as I said in the introduction, this topic serves to remind conveyancers of the obligations when it comes to paying commission over to estate agents. So as a segue into the topic, I want to explain why we want all estate agents to be registered with the PPRA. Right, so reason number 1, to ensure compliance with our educational and training requirements. And here I just need to explain that you don't wake up one day and decide that you are going to sell properties and earn commission and come to the PPRA and they will issue with an FFC, and then you can go ahead and practice. That is not how it works. There are very stringent requirements with which you must comply, educational requirements, training requirements. There's a pathway that you follow before you become a fully fledged property practitioner. You start off as a candidate. You have to work a certain amount of time to gain place experience. You need to have certain qualifications to move to the next level, which is a non-principal property practitioner. From candidate attorney, you will move candidate property practitioner. You will move to non-principal property practitioner. But before you get to move to that level, you need to have certain qualifications in place. There's an exam that you need to write and pass. And only after you've done that will you move to that level of non-principal property practitioner. The level after that is principal property practitioner. Again, there's educational requirements that you must comply with. There's an exam that you need to write and pass. And only once you've done that, do you move and become a principal property practitioner. So that's the first reason we want estate agents to be registered with us so that we can ensure that they've complied with those stringent educational and training requirements. Second reason, we want to ensure compliance with the Act and the Code of Conduct. So we want to know who is out there practicing in the industry. They must be on our database. We want to know who they are, where they are, so that we can ensure that they are in compliance with the Act and the Code of Conduct. And how we do that, we have an inspections department which regularly goes out and conducts inspections to make sure there's compliance with the Act, to make sure there's compliance with the Code of Conduct, right? Another reason we want estate agents to be registered is so that we can ensure that consumers are protected from dealing with unregistered, untrained and or unscrupulous estate agents. That's the reason we have this educational requirements in place. That's the reason we conduct regularly inspections to make sure that consumers are dealing with well-trained, well-qualified and professional estate agents. And the last reason that we want estate agents to be registered with the PPRA, for me, is the most important reason, right? And that reason is that consumers who suffer financial loss at the hands of unregistered estate agents are not covered by the Fertility Fund. And I can speak, from personal experience. I can't tell you how many times I've had to give the sad news or the bad news to a member out there of the public who's come to us crying in his hands, telling us that he's lost his hard-earned savings at the hands of someone who claims to be a property practitioner. And then we have to give that person the unfortunate news that we as PPRA cannot assist, because the person that committed the theft of the money or misappropriated the money has not been issued with a valid Fertility Fund certificate, and that the Fertility Fund only covers loss suffered at the hands of practitioners who were issued with a Fertility Fund certificate. So that is for me, one of the most important requirements of us wanting all property practitioners to be registered with the PPRA. Right, so now I'm just going to take you to some of the important provisions of the Act which we want conveyancers to be aware of. All right, Section 48 of the Act, Section 48 subsection 1, makes it an offense for any person to act as a property practitioner unless that person has been issued with a fertility fund certificate. Please take note, it makes it a criminal offense for any person to act as a property practitioner unless that person has been issued with a fertility fund certificate. Section 56, subsection 1 says that, in summary, it says that a person is not entitled to commission unless in possession of a fertility fund certificate. So anybody that acts as a property practitioner and at the time of performing that transaction as a property practitioner, they were not in possession of a fertility fund certificate, they are not entitled to commission. All right. And now I want to come to the provision that we believe is important for conveyancers to be aware of. And that is why we are grateful for this opportunity that we can address conveyancers specifically and just remind them, because we believe that they are aware of this provision, but we still receive so many reports of estate agents successfully practicing out there, successfully making money, being paid commission, and not being in possession of a fertility fund certificate. So the only conclusion that we can reach is that some of the conveyancers out there are not adhering to this section. So I want to read this section out in full to you. It says that a conveyancer may not pay any remuneration or other monies to a property practitioner unless that property practitioner has provided the conveyancer with a certified copy of his, her, or its fertility fund certificate, valid during the period or on the date of the transaction to which such payment relates, and on the date of such payment. All right, take note of that. It must be this fertility fund certificate must have been valid at the date of the transaction and on the date that you make that payment of commission over to the estate agent. Right, and then further the provision reads, where all relevant conditions have been met, the conveyancer must pay the remuneration and other money. So only where that estate agent has confirmed that he or she was indeed in possession of a valid fertility fund certificate on the date of the transaction and on the date that payment has been that payment has been made to that estate agent. Please take note of that very important provision of the Property Practitioners Act. We understand that the Property Practitioners Act in general does not apply to conveyancers, but to property practitioners. But this particular provision in the Act is addressed to conveyancers, and it's an Act of Parliament. So it's law, it's legislation, which conveyancers are obligated to comply with. And please keep in mind what I mentioned in the earlier slide about the requirement that fertility fund claims will only be paid where the theft was committed by a property practitioner who was in possession of a valid fertility fund certificate. We see so many examples of people coming to us that they were dealing with an estate agent that was unregistered, and conveyancers, through their conduct of paying over the commission to that estate agent, is aiding and abetting their criminal activity, which has been made a criminal offense in terms of Section 41, Section 48, subsection 1 of the Act. All right. So by paying over that commission to that unregistered estate agent, you are furthering the criminal activity of that estate agent. So please, conveyancers, please take note of that important provision in the Act. All right. So I think now we can move on to the third topic. And the third topic is the topic that formed the basis of the recent communique that we published on the 2nd of June 2025. So the purpose of the communique was firstly to create awareness of the issue, and from the PPRA side was to remind property practitioners of the applicable provisions of the Act and to warn them of the consequences of non-compliance. Secondly, the communique aimed to set out how PPRA would interpret the word arrangement in the provision, since it's not defined in the Act. So the provision in the Act, Section 58(1)(b), uses the word arrangement, and that word arrangement has unfortunately not been defined in the Act. So the purpose of that communique was to advise as to how the PPRA would interpret that term, to what the PPRA would interpret that term to mean. So in that communique, we cited the section. We cited Section 58, subsection B, and it reads as follows. A property practitioner may not enter into any arrangement, formally or informally, whereby a consumer is obliged or encouraged to use a particular service provider, including an attorney, to render any service or ancillary services in respect of any transaction of which that property practitioner was the effective cause. So we set out our interpretation of the word arrangement, which we would interpret to mean any arrangement of any kind in terms of which the estate agent stands to gain any financial benefit in return for obliging or encouraging a seller to appoint that conveyancer. All right. So, as I said, the term arrangement is not defined in the Act. We need to communicate to estate agents how we, as the regulator, would interpret that word, and that's what we've tried to do in that communique. Now, in response to the communique, the communique seems to have created some panic amongst estate agents, and we received queries. They've asked us questions like the following. May I now not go out for coffee with a conveyancer anymore? That's the type of question that we received. So estate agents were now concerned that any interaction with conveyancers would be seen as an arrangement, and that is not the case. So that question of wanting to know whether that estate agent is now not allowed to go out for coffee, as an example, with a conveyancer, that question is absurd. We are not attempting to regulate friendships and police who estate agents may interact with socially. As I said, that would be absurd. What we are saying is that our interpretation of Section 58(1)(b) of the Act is that an arrangement is an arrangement of any kind in terms of which the estate agent stands to gain any financial benefit in return for obliging or encouraging a seller to appoint that specific conveyancer. So there has to be certain conduct on the part of the estate agent, and this conduct must be in the form of obliging or encouraging the client to use the services of the conveyancer from whom they receive some form of financial benefit. So ordinary friendships, ordinary social interactions where there is no conduct on the part of the estate agent to oblige or encourage a client to use that conveyancer after having been receiving some form of financial benefit, that type of ordinary interactions does not fall within the category or the definition as we would interpret it of an arrangement. All right. And we do understand that it will be difficult to quantify what is meant by a financial benefit. We understand that. And we also understand that it will be difficult to define in detail what a financial benefit is meant to be, right? We have, however, in the communication tried to provide some examples. And if you can refer to that communication, you will see we've listed some examples. Please note that that list is non-exhaustive. It's difficult to, as I said, to define every scenario or every possibility that would fall within the category of an arrangement, and we've just tried to highlight some examples just to give estate agents and LPC members an idea of what it is that we are referring to. But as I said, the list is not an exhaustive list. Also, I just need to highlight that it should be noted that we are under no illusion that convicting an estate agent for contravening Section 58 is going to be easy. We understand the difficulty. We understand the difficulty in gathering the requisite evidence and to prove non-compliance. We understand it's not going to be easy. However, we have the view that just because it's difficult, it does not mean that we should fold our arms and do nothing about the situation, right? So what we are trying to do through this webinar, through the communication, the communique that we published, is to create awareness and to deter estate agents from entering into these arrangements with conveyancers. We firmly believe that convictions by the PPRA and the LPC, accompanied by serious consequences, would act as a deterrent and would make a dent in this practice, which I understand has been coming on for many, many years. And if we do nothing, it will continue. So this is the initiative that we've embarked on together with the LPC, and we'll do our part from the PPRA side and take action against our members, and we trust that LPC will do the same with their members. And as I said, if there's convictions and there is serious consequences, it would certainly act as a deterrent for others out there to think twice about getting themselves involved in such arrangements where clients are obliged or encouraged to use only certain conveyances because that conveyances are providing financial incentives or some form of financial benefits are being handed over to that estate agent. All right. So having said that, let's look at the possible consequences for estate agents should they be found guilty of contravening Section 58(1)(b). All right. So if we as PPRA find that there is sufficient evidence that substantiates a charge that can be brought against that estate agent will be charged with sanctionable conduct in terms of Section 30 of the Act and brought before an adjudicator. And here I just need to point out there appears to be a misconception, which I want to correct, that it is not PPRA that convicts, it is not PPRA that imposes the fine. It is the adjudicator that has been appointed. It's an impartial and independent adjudicator in terms of our Act, in terms of Section 30 of our Act. We are mandated to appoint an adjudicator, and that adjudicator will determine whether the person is guilty or not guilty of sanctionable conduct, and that adjudicator will then impose a sanction on that person. PPRA's role is to present the evidence at that adjudication hearing. PPRA will act as the prosecutor and present the evidence to the adjudicator. The respondent in the matter will have the right to put up a defense, to present their own evidence, to call witnesses, to cross-examine. They have the right to legal representation as well. So we have to comply with fair and just administrative action. We have to ensure that that adjudication hearing complies with the PPRA. Because of course, if it does not, that respondent then has recourse to the courts to review any administrative action that has been embarked on by PPRA. So after that hearing has been conducted, and should the adjudicator find that the person is guilty of sanctionable conduct, that person can be sanctioned with a fine of up to 200,000 rand, and depending on the severity of the contravention, it is possible for that person's FFC to be withdrawn as well. So that is the consequences for contravention of any provision of our Act or Code of Conduct, but I'm referring now here specifically to contraventions of Section 58(1)(b). That is the process that we will follow should we receive information that is sufficient for us to take to a information and evidence, let me add, information and evidence which is sufficient for us to take to an adjudicator and upon which we can formulate charges. We will do so in terms of Section 30 of the Act. All right. I think that brings my presentation to a close, so I'll just make the following closing remarks. So the purpose of our collaboration with LPC is to, as I said, create awareness, which we have tried to do through that communique, and which we are trying to do now through this webinar. Also, to request assistance from conveyancers, as I've done in this presentation, to report unregistered estate agents to the PPRA. I'm going to just repeat that call, please, conveyancers, please take heed of Section 56, subsection 5 of the Act, which I've just highlighted to you. It's very, very important. It will assist us. If all conveyancers comply, we will definitely root out those unregistered estate agents out there that are posing a risk to consumers. All right. And another reason for our collaboration with LPC is to ensure combined enforcement of legislation and codes of conduct to create that deterrence which I was speaking about in the industry with regards to prohibited arrangements. So PPRA calls on estate agents and LPC members to continue doing their part to comply with their respective codes of conduct and to report incidences of non-compliance. Complaints against estate agents can be reported to the PPRA by logging a complaint on its website. It's a simple process. You log on to our website and there's a online complaints portal that if you click on it, it will take you to a form that you need to complete where you can provide us with all the information. It allows you to attach substantiating documents which you have in your possession, which will serve to substantiate your complaint. And once we've received that, we will then proceed to investigate that complaint And as I said, if we find that we have sufficient evidence before us to prefer charges against that estate agent, we will do so. And hopefully it will result in a conviction and consequences and that deterrence, as I mentioned. That brings my presentation to an end. Kabelo, I'm going to hand back over to you. I think I'll also stop sharing my presentation. Kabelo?
Thank you very much, Mr. Caton. And I'd now like to hand over to Mr. Tembinkosi Nqobo. Mr. Tembinkosi Nqobo is our Senior Manager, LPC Law Library. Mr. Nqobo will take us through the Q&A and comments and questions that have been posted on the chat. Mr. Nqobo, over to you, sir.
Thank you, Mr. Tebele. Greetings to our LPC Executive Officer, PPRA team and colleagues. I've taken note of the fact that some other people have decided to post their questions on the chat space. So what I'll do, I'll first go through all those questions that have been posted on the chat space, then move to those that are in Q&A space. And I've seen that Tracy has responded to some of the questions, but for the benefit of those that have not been able to see the questions and the response, I'll ask her to also respond verbally to those questions. Going for the first question, it started with a comment. We've been advised by a few agents that they have applied for their Fidelity Fund certificates, but there is a huge delay in those certificates being issued. How do one handle this situation?
Mr. Caton or Ms. Deli Nkambule, would you like to respond to that?
I'll leave it to Deli. Deli, you going to respond?
Yes, I can. So what we would like to request for those that, for conveyancers that meet agents that say they have an issue with their FFCs, is to escalate it to our registrations department. We do accept that sometimes there is a delay, but sometimes the delay is caused by one or two applications that are not compliant. And then, it causes a delay. But maybe what we can do is we can request the registrations department to give us a specific email address where conveyancers can email and just query about a certain, property practitioners Fidelity Fund, especially those that say their applications have been delayed. But I think as the PPRA, we are here to assist conveyancing attorneys who say that they are dealing with property practitioners whose FFCs have been delayed. So I think that's how far, Clarence, I can put it, but we are willing to assist. There are issues, but most of the issues are caused by non-compliance from the property practitioner side. And those where we have delayed, we would then be able to issue an affidavit confirming that the property practitioner was entitled to an FFC on this particular day, and he should have been issued an FFC, and then we can give it to the conveyancing attorney so that we make sure that we do not disadvantage an estate agent or a property practitioner from being paid their commission. Thank you, colleagues.
Mr. Nqobo?
Okay, thank you so much, Deli, for that response. There is a second question. I think this one needs to know if the business broker has exemption certificate on sale of commercial property. Anyone to respond on this one? Caton?
Yeah, I'll respond. There's no general exemption. The person must apply for an exemption. If the person is a business broker, person must then apply to a PPRA for an exemption. As far as my knowledge goes, there's been no general exemption for all business brokers. Each business broker or individually must approach the PPRA. Thank you.
Okay, thank you so much, Clayton. Okay, this one needs to know as to what steps does an attorney need to take in order to act or register as an estate agent. Any response to that?
I'll go. Delhi, you want to answer it?
No, it's fine. I can assist where you need, but you can go ahead, Clarence.
All right. So there's the attorney must just have a look at our definition of property practitioner in the Act, right? There is an exclusion for attorneys who, and I'll just refer to it, in the course of and in the name of and from the premises of perform the functions of a property practitioner, then they excluded from the requirement of applying for an FFC. However, if the attorney acts under a different name, performs property practitioner functions under a different name that is different from that attorney firm, then they would require to apply for an FFC. And that is what I tried to introduce or discuss in the presentation. There are certain requirements that have to be met. So they will have to approach the registrations department. The registrations department will guide them as to what they must comply with, if it is that they are practicing under a different name. But please refer to Section 1 of our Act just to confirm whether you are excluded or not. If you fall within that category there in the definition that excludes you as an attorney, then you do not require that FFC. But if you do not fall within that definition, approach our registrations department. They will confirm with you what specific requirements you need to meet. Thank you.
Okay, thank you, Clayton. Okay, there's another question. How do you define financial benefit? I think this question stems from an allegation that estate agents are being sent on training courses and lavishly spent on at monthly banquet by some of our law firms.
Yeah, so in my presentation, I did mention that it's difficult for us to define financial benefit, right? But there's two forms of conduct here that must take place. One from the conveyancer to, as an example, that training course that you mentioned. But then in return for that training course, there must be conduct on the part of the estate agent. So the estate agent must then oblige or encourage his clients to use the services of that conveyancer who has sent him on that training course. That will create that link that in our interpretation of that word arrangement, that we could be seen as an arrangement where that form of financial benefit, the financial benefit where that estate agent has saved that training cost and somebody else has covered that training cost. But in return for covering that training cost, that person is now being referred work from that estate agent. So that would, in our view, fall within the category of an arrangement. But it's very difficult to define financial benefits because there's so many variations, so many possibilities. So we'll have to look at each case on its own merits and determine whether the estate agent did something in return for that training course, and was that something in return a referral to that conveyancer. Thank you.
Okay, thank you so much. Next question. Can a conveyancer sell or assist in the sale of a property for a client seller without using a property practitioner? And if so, is commission payable to the conveyancer? Did you get that one, Clayton?
Yes, again, please refer to Section 1 of the definition of a property practitioner, make sure if you fall within that exclusion. There is an exclusion, as I mentioned in answering the first question, where it says that if you are an attorney who, on your own account, or as a partner in a firm of attorneys, or as a member of a professional company as defined in the Attorneys Act, or a candidate attorney defined in that section, and you perform an act referred to in the definition of a property practitioner in the course of and in the name of and from the premises of your attorney firm, then you would be excluded according to that definition. So it's difficult to answer you definitively without having that details. You can go and have a look at that exclusion in our act. If you fall within that exclusion, then you do not need an FFC. But if you do fall within it, not fall within it in that exclusion, then you can't then sell properties without being issued a FFC by the PPRA. Thanks.
Okay, next one. A particular agency alleges that the fidelity fund certificate for company is sufficient and that the individual agents do not require fidelity fund certificates. The agents allocate their work to a specific law firm who do not question this and who obviously give some form of financial benefit. The agents discourage clients that want to use our services from doing so, as we insist on fidelity fund certificates. How do we deal with this situation? Any advice?
Please report it to us so that we can deal with that firm that is employing unregistered agents, because from the question it sounds like the firm has an FFC, but the agents doesn't have an FFC. Our act requires both the firm and the employees of the firm, the agents, to be in possession of a valid fidelity fund certificate before they can perform the role or perform the acts that are defined in the act as acts that may only be performed by a property practitioner. So please report it to us. If we don't know about it, there's nothing that we can do about it. So I'm glad you reported it here, but we need to receive it as a formal complaint. So please go onto our website, or if you wish, you can contact me. Kabelo can just indicate whether my details are going to be shared after this webinar. You can contact me for further information. I will assist you in how to report it to us. Thanks.
Okay, here's another interesting one. What about attorneys that are not qualified conveyancers but do a lot of transfers for property practitioners, which is frowned upon due to some of these arrangements? The LPC must look into these attorneys and forbid transfers being attended to by lawyers who do not qualify as conveyancers and therefore not adhering to these regulations.
Yeah, that's for the LPC. That's for the LPC to answer.
Yeah. I think that was just a comment, if I'm not mistaken.
And I think if there are any specific complaints, they can be lodged and they'll be referred to our respective provincial offices to be looked into. Thank you, Mr. Ngoba.
Okay. Can I just touch on the questions from the Q&A? The first one, are agents with valid FFCs entitled to receive commission after suspensive condition are met, but before registration, if the OTP allows for it?
Clarence, can I go?
Go ahead, Ellie.
Yeah. Sorry about that.
Yes, sir.
The code of conduct prohibits that and usually requires that the commission is paid once the the transaction has been registered. I know that there are some agents who usually put it in the OTP to say once the suspensive conditions have been met, then they're entitled to the commission. But the code of conduct prohibits that. So we would really like conveyancers to ensure that property practitioners are paid their money once it's due, in terms of ensuring that they're paid once the transaction has been sold, because we do see a lot of complaints coming through whether the buyer is now unhappy with certain issues in the property and the commission is already paid to the estate agent or the property practitioner. Sometimes the sellers are willing to withdraw from the transaction, but the commission is already paid. So then the seller, the buyer finds themselves being disadvantaged. Thank you.
Okay, thank you so much, Deli. The next question. In relation to section 56, subsection 5, with developments, there can be a gap of several years between date of sale to date of transfer. If an estate agent has valid FFC at the time of sale, but retires before the date of registration, are they entitled to commission?
So, are you going to answer the? Okay, go ahead.
Okay, sorry, Clarence. So our Act says the agent must be in possession of an FFC at the sale as well as at the time of payment. So if the person is no longer in possession of a valid FFC at the time of payment, but was in possession of an FFC at the time they entered into a transaction, then they're not entitled to the commission. It would then be important for the agent to ensure that they have a valid FFC to be able to retain their commission or gain their commission, and then they can retire once they've received their commission. But the valid FFC is required at the point of transacting and at the point of payment.
Okay, thank you so much, Deli. The next question, in relation to a certified copy of the FFC, should this be the originally certified copy, or does a scanned certified copy suffice for the purposes of section 56, subsection 5? Kaiten?
Clarence, are you there? Can I go ahead?
Yeah, go ahead, Deli.
Okay, so it says a certified copy. If it's certified, whether it's scanned or emailed, for me, it's really, I don't think there's a problem, because electronic communication is accepted. So as long as it is a certified copy, it suffices. I don't know if I've answered that question well.
Okay. Kabelo, I think I've read out all the questions that were posted. Can I just hand it over back to you? Thank you.
Thank you very much, Mr. Ngobo. Thanks for taking us through the Q&A. I want to check with Ms. Delinkambule and Mr. Payton. Is there any final thoughts, or is there anything else maybe you want to mention before we close the session?
I'll just let Deli first go. Deli, do you have anything that you want to add?
No, I think mine is just briefly to, first of all, thank the LPC for the platform and to the conveyancing attorneys that have attended. We definitely, as the PPRA, are looking forward to a working relationship between ourselves and the LPC, especially with conveyancing attorneys, because they work closely with property practitioners. Whatever assistance that they need, I know one of the questions related to agents that are alleging that they are failing to get their FFCs in time, and therefore, it's creating issues when they are dealing with the conveyancer. So in that aspect, as the PPRA, we are willing to assist and ensure that, these agents can be able to get their commission, and that conveyancing attorneys can be able to at least confirm that these property practitioners have FFCs or have applied or are entitled to their commission because they've applied for the FFCs. Other than that, we really want to also urge, assistance from the conveyancing attorneys to please report any property practitioner that they are working with who is not registered with the PPRA. And I think Mr. Clarence has specified why it's important, because not only are we then allowing people who are not registered to continue to trade illegally, but we are also subjecting consumers to property practitioners that are not trained. And as a result, we get a lot of complaints regarding misconduct from property practitioners failing to disclose defects in the property, and then it causes a lot of issues between the seller and the buyer. So that is all from me, but thank you so much for the platform. Thank you to the conveyancing attorneys as well.
Thank you so much, Ms. Nkambule. I just want to reiterate that the recording of this session will be made available. It will be on the LPC YouTube channel at the latest on Monday. And I do note the request for the presentation as well as the request for the contact email. So I will add that. We will place that on our social media and on our YouTube channel. So at this point, I would like to convey my word of thanks to Mr. Clarence Caton, Ms. Deling Kambule, Ms. Naledi Mpahlele, and everyone from the PPRA. Thank you, colleagues, for your collaboration and partnership as we're setting this up, and for the many discussions that we've had between the LPC and yourselves to make this webinar a reality. Secondly, I'd like to say thank you to the LPC team, my executive officer, Ms. Charity Nzuza, the directors that joined us today, my colleagues, and everyone within the LPC, as well as our members of council who joined us today. Lastly, I'd like to say thank you to you, legal practitioners, for taking time out on a Friday afternoon to join us for this webinar. Your time is appreciated. If you do have any comments, suggestions, please send us an email on info@lpc.org.za, info@lpc.org.za. If it's specific to the webinars, please make it for the attention of the communications department. And we do look forward to receiving your feedback. On that note, thank you, everyone. Have a wonderful rest of afternoon and a wonderful weekend. Thank you.